driven away our keynote speaker. And it's a great pleasure to welcome Fred Schauer back to the law school. He's been here a couple of other times. And he'll be, as I said, he's our keynote speaker. Fred Schauer is one of the country's preeminent thinkers about the First Amendment. He has been, he's now at the University of Virginia, and before that, he held for a First Amendment person what must be one of the great named professorships anywhere. He was the Frank Stanton Professor of the First Amendment at Harvard, and before that, he was at Michigan, and he's visited at a raft of other places. Fred has written a number of books and I guess it's hundreds of articles at this point on First Amendment issues, jurisprudence, philosophy of law, and I've taught a fair number of Fred's works in various of my courses over the years. So it's my pleasure, to, as I said, to welcome Fred Schauer back as our keynote speaker.
Thank you. I'm delighted to be here. I'm not really sure what the role of a keynote speaker is. I've heard some number of keynote speeches, and they tend to fall into two models. One is the model of the famous but clueless outsider. So one can imagine for a topic of this sort, you might have a retired political figure who had spent a long time in the Senate and said, well, I'm delighted that you've invited me here to talk about government speech. I was in the government for a long time. I made a lot of speeches. Let me tell you about one of the speeches that I made, and has no idea of what the topic was actually about. Then there's the over-the-hill luminary. I don't believe I'm a luminary, and I hope I'm not over the hill, but someone who will talk about how the current topic is really what the over-the-hill luminary was thinking and writing about 30 years ago, and there's nothing new to say, but I suppose that I will say something. I hope not to follow either of those models. So let me begin with, again, my thanks for inviting me and thanks for letting me occupy this particular role at this interesting and important conference and event. So one of the many interesting things about the topic of government speech is that as a topic, it is so different from the topic that paraded under the same banner and the same label 30 years ago. So 30 years ago, people like Mark Yudof, now the president or chancellor or king or whatever the appropriate title is at the University of California, Mark Yudof and Robert Kamenschein and Steve Schifrin and William Van Alstyne and some number of others were writing about the question of whether the First Amendment restricts what government can say with its willing employees. That is, it was largely the topic of propaganda. So one way of thinking about this is that if we go back in the history of First Amendment theory and think about the classic marketplace of ideas, search for truth, rationales for freedom of speech, going back to John Milton and then John Stuart Mill and then Oliver Wendell Holmes, the background theoretical assumption, and these are not the only theories that are out there, but the background theoretical assumption was that if many voices could contribute to public debate, then something about human rationality or something about the intrinsic power of truth would enable truth to emerge from this unfettered or unregulated marketplace in ideas. Against that background, people like Udolph and Kamenschein and Schifrin in part, and Van Alstyne and some number of others, were worried that this idea, this model, this notion that the truth had a fair amount of explanatory force in determining which ideas would be accepted and which would be rejected, would founder if there were market failure in the marketplace of ideas, and for them the most prominent form of market failure would be the dominant voice of government. The fear, as it was put then, that government's voice would drown out all of the others. And therefore the question that they and others put on the table was the problem of, are there First Amendment limitations on the ability of government because of its resources, because of its access, because of the inherent authority of government to drown out other voices? Putting aside the question, the special and important question that will be the post-lunch panel, putting aside the question of the religious issues arising under the Establishment Clause of the First Amendment, the form of government speech or the form of government speech problem that I have just described has largely disappeared. One reason it has largely disappeared is that when arguments that were in the vicinity of this kind of government speech problem, government drowning out everyone else, were raised in the courts, they were largely unsuccessful. Meese versus Keene is one U.S. Supreme Court case embodying this, and there are some number of others, but the notion that people could restrict the government from adding its allegedly powerful, allegedly authoritative, allegedly drowning out voice to the marketplace of ideas essentially got nowhere in the courts. In addition, these days, to put it mildly, we don't worry about the authority or dominance of the government's voice. We could talk about this at some length, but the notion that government, because it is government, has a degree of respect, authority, cachet, or whatever we would want to call it, compared to all of the other voices out there as an empirical matter, doesn't have the resonance that it had in 1980, and frankly, even it didn't even have that much resonance in 1980. So for whatever reason, whether my empirical claims are right or wrong, the problem of government speech as it was framed 30 years ago is very different from the problem as it is framed now. As it is framed now, the problem of government speech, as I said, is different. Possibly going back to Rust versus Sullivan in 1991 and crystallizing in Garcetti versus Ceballos, perhaps further crystallizing in Pleasant Grove versus Summum. The Supreme Court has said that one way of resisting the claim of a government employee or a government contractor or a government grantee to be immune from removal from employment or withdrawal of the grant for what that employee or grantee says is to recognize the government's ability or power, not right, the government's ability or power to speak, and thus to use its power or ability to speak or grant money as a way of effectuating this. In other words, the modern government speech doctrine, insofar as it is a doctrine, developed as a defense to a claim of a right on the part of a contractor, defense to a claim of a right on the part of a government employee to speak. And although there are some areas of overlap, this modern government speech problem, to a significant extent, the product of Rust versus Sullivan and what came afterwards, is rather different from the government speech problem as it had been framed somewhat earlier. But now we have to go back even further. For if we were thinking and writing and debating and arguing on a blank constitutional and doctrinal slate, it is hardly obvious that government needs the government speech doctrine, as I have just described it, at all. Or to put it somewhat differently, again, assuming you can decide whether this is correct or not, assuming ignorance of intervening doctrine, assuming ignorance of First Amendment principles, someone might say, whoever would have thought otherwise? Whoever would have thought that government cannot use its power of the purse, its voice, or anything of that variety to say what it wants? And if we at least recognize that pre-legal, pre-constitutional, pre-First Amendment intuition, it brings us back in a way to where the story starts. So let me go back a little bit in history, because I think the story starts with Oliver Wendell Holmes. It starts with his canonically rejected statement in an 1892 case called McAuliffe versus the mayor of New Bedford. So I say canonically rejected. There are cases out there that are important not because they are right, but important because they are so widely understood to be mistaken. Obviously, the classic version of this is Dred Scott versus Sanford, but it's not the only one. For a long time, until about maybe 10 years ago, Lochner versus New York was one of these. And to describe someone as Lochner-ing or Lochnerizing was to insult the argument or insult the case or insult the principle. Lochner has been subject to somewhat of a rebirth or reputation rehabilitation recently, but before the recent rehabilitation, again, it was a case whose importance derived from its wrongness rather than from its rightness. And indeed, but for Buck versus Bell, in which Justice Holmes informed us about the number of generations of imbeciles that were enough, it is possible that McAuliffe versus New Bedford would have served as the most important Holmes decision of this variety. Nevertheless, McAuliffe versus the mayor of New Bedford has, for a long time, since its 1892 decision, served in this manner. So let me say a little bit that is served as the, of course we wouldn't want that. Of course we wouldn't want to go back to McAuliffe. So let me talk a little bit about McAuliffe versus the mayor of New Bedford. McAuliffe was a policeman in New Bedford, Massachusetts. During the thriving days of New Bedford, with the demise of the whaling and textile industries, is now a city on somewhat hard times, but in the late 1800s, when both whaling and textile and other forms of fishing were thriving, so was New Bedford. John McAuliffe was a New Bedford policeman. He had joined the political club, and he'd given a number of political speeches. And as a result, he was fired for violating New Bedford's equivalent of the Hatch Act. So let me quote a little bit. The appropriate regulation or the relevant regulation, no member of the department shall be allowed to solicit money or any aid on any pretense for any political purpose whatsoever. So McAuliffe was disciplined for this as a result and fired for this. And as a result, he brought a mandamus action in the Massachusetts Supreme Judicial Court. Those of you who have survived the very first day of constitutional law are aware of original jurisdiction in mandamus actions, or at least controversies surrounding them, not only in the federal system but also in state systems. McAuliffe brought his suit as a mandamus mandamus action, originally in the Supreme Judicial Court. As with original jurisdiction actions in most high appellate courts, the court was not interested in actually doing any fact-finding. It appointed a special master to conduct a hearing on Mr. McAuliffe, or Constable McAuliffe's claim, and then the case went directly for actual decision on the merits to the Massachusetts Supreme Judicial Court, on which Justice Oliver Wendell Holmes then sat. So now we get closer to what's somewhat important. The case is very short. One of the nice things about 1892 cases in general and 1892 state cases in particular is that they were all short. And there weren't very many concurrences, there weren't very many dissents, and there certainly weren't very many, I agree with the majority in parts 1, 2, and 3, concur in the judgment on part 4, and concur in the result on part 5, except for footnotes 1 and 2. That didn't exist in the Massachusetts Supreme Judicial Court in 1892. So what we have is a 2-page opinion, most of which is about what we would now call procedural due process, and whether the hearing was sufficient and so on, and the court said it was. The entire opinion on the relevant matter is as follows. It is argued by the petitioner that the mayor's finding did not warrant the removal, that the part of the rule violated was invalid as invading the petitioner's right to express his political opinions, and that a breach of it was not a cause sufficient under the statutes. One answer to this argument, assuming that the statute does not make the mayor the final judge of what cause is sufficient. So Holmes leaves open the question of maybe this is 100% discretionary with the city. Assuming that the statute does not make the mayor the final judge of what cause is sufficient, and assuming, therefore, that we even have a right to consider this case, is that there is nothing in the Constitution or the statute to prevent the city from attaching obedience to this rule as a condition to the office of policeman, and making it part of the good conduct required. The petitioner may have a constitutional right to talk politics, but he has no constitutional right to be a policeman. There are few employments for hire in which the servant does not agree to suspend his constitutional rights of free speech as well as of idleness by the implied terms of his contract. The servant cannot complain, as he takes the employment on the terms which are offered him. On the same principle, the city may impose any reasonable condition upon holding offices within its control. This condition seems to us reasonable, and that be if that be a question open to revision here. That's it. That's every word, every syllable that Holmes said on this subject. Nevertheless, it has become the canonical statement of what many would think of as the old view, the outmoded view, the obsolete view, or whatever. It's worth speculating, and at least as far as I've been able to find the records, can't do much more than speculate about what was actually behind this case. There's no particular indication that McAuliffe was a dissenting voice, that is, that he was an outspoken dissenter from the policies of the police department, which is a role that many people in government in these kinds of cases play nowadays. There's no particular reason to believe that he was a whistleblower. There's no reason to believe that he had discovered something untoward in the bowels of the records or procedures of the police department. This was probably one of two varieties of case. There's a good chance that it was a patronage case, and that although this case arose in 1891, decided in 1892, it is, at least for me, of some interest that from 1892 until 1935, the number of mayors that New Bedford had was 1. When you discover a city in which the same person was the mayor from 1892 to 1935, you are at least suspicious that this is a political machine. You are at least suspicious that a powerful political machine exercises its power in terms of the appointment of all governmental officials, including but not limited to police officers, and that in fact McAuliffe's actual crime or actual sin was bucking the political machine, and that this case was really a question at the rise of what we now think of as civil service reform. A case that was really about the competing merits and arguments for political patronage on the one hand and civil service reform on the other, with McAuliffe perhaps on his own behalf or perhaps in the service of others representing the non-patronage side of that argument. The other possibility, and we don't know, is that this was a union organizing case. One of the things we do know, of course, is that this was the early years of police organization and police unionization activity, a range of activity that some years later produced the presidency for Calvin Coolidge, who became president by dealing firmly, shall we say, with the police strike in Boston. Things were starting, even by the early 1890s, police unionization activity had started. In Massachusetts, it had a strong ethnic component. In New Bedford, in this case, as with the Boston police strike 30 or 40 years later, most of the members of the police department were of Irish ancestry. Most of the powers that be were of Yankee ancestry. So this union management dispute was also a Yankee versus Irish dispute, and it is at least possible that McAuliffe was a union organizer. But what we are pretty sure of is that he was not at the center, not a whistleblower, and so on. Now, Holmes's quote, this entire opinion, has been taken to be the embodiment of what is known as the right-privilege distinction. In 1968, William Van Alstyne wrote an enormously important article entitled "The Demise of the Right-Privilege Distinction in Constitutional Law." In 1968, it was considered entirely appropriate and doctrinally justified for someone with Van Alstyne's eminence to say, well, there was a right privilege distinction that because McAuliffe had a privilege and not a right, he had no constitutional right to speak. But Van Alstyne says in 1968 that is now dead. The doctrine no longer exists, and that the fact that McAuliffe had no right to be a policeman doesn't mean that he gave up the constitutional rights he would have had as a citizen to speak out, what Holmes said in 1892 notwithstanding. Van Alstyne's conclusion was largely the product of what aficionados of the First Amendment like to call McCarthy-era cases. I say aficionados of the First Amendment like to call McCarthy-era cases because none of them actually took place during the McCarthy era. The Supreme Court was not particularly active, to put it mildly, during the McCarthy era. Some people attribute that to cowardice. Some people attribute it to Brown versus the Board of Education. After all, the Supreme Court had other controversial things on its plate at the moment, and it's a historically open question whether the Supreme Court's passivity, whatever, in the early to mid-1950s on McCarthy-era restrictions was strategically wise or just cowardly. In any event, the McCarthy-era cases are largely cases from the early to mid-1960s, cases like Wieman versus Offthejob, Keishian versus the Board of Regents, Elfbrandt versus Russell, and some number of 1960s cases that were appropriately taken by Van Alstyne as signaling the demise of the right-privilege distinction. Many of these cases were loyalty oath cases, and the underlying assumption was that merely getting a license from governments or getting a job from government or something else from government was not sufficient justification to permit government to condition that job, that license, that anything else on the relinquishment of what would otherwise be constitutional rights. Almost all of these cases, as I said, were McCarthy-era holdovers. Most of them involved loyalty oaths. Most of them involved various required professions of non-communism or unwillingness to overthrow the government. The cases are interesting and maybe bizarre for that reason. The target of these loyalty oaths and government restrictions was a group of people, or perhaps an imagined group of people, who, so it was thought, would be willing to deliver nuclear secrets to the Soviet Union, would be willing to overthrow the government of the United States by force and violence, would be willing to commit treason in some number of other forms, but would be unwilling to lie about their past associations and unwilling to take a loyalty oath that did not represent their sincere beliefs. Whether such people ever have existed is an open question, and it's certainly plausible to imagine that by the time the Supreme Court got around to imposing these substantial restrictions throughout the 1960s, the problem, if it ever existed, had ceased to exist. But the court said on some number of occasions that government employment, or by extension things like public housing, or by extension welfare benefits and some number of things of this variety, could not be conditioned on what would on someone relinquishing what would otherwise be their constitutional rights. Arguably, the most relevant case of this line for our purposes is a 1968 case called Pickering versus the Board of Education. In Pickering, the Supreme Court protected the right of a school teacher to criticize the school board at a school board meeting and in public, and the Supreme Court upheld the school teacher's free speech rights against the claim, the Holmesian claim that by accepting employment as a school teacher, he accepted the conditions that he would not criticize the school board. And it is Pickering, perhaps more than any other, that relates to what we're talking about today, but Pickering is merely an exclamation point. When Van Alstyne was actually writing his article, Pickering had yet to be decided, but it is the line of cases ending with Pickering that represents or what was thought to be the definitive rejection of the Holmesian view in McAuliffe versus the mayor of New Bedford. So now let's go back to Constable McAuliffe for a moment and ask the question, would Constable McAuliffe have fared better today? Or even, would Constable McAuliffe have fared better in 1968? Have we overstated the rejection of what Holmes said in McAuliffe? So we could first imagine the question, Suppose that Constable McAuliffe, I don't know what his actual title is. It might have been patrolman, it might have been policeman, but constable sounds better. We have this image of somebody walking the beat with a large belly and a high hat with a point on the top. So let's call him Constable McAuliffe. Would Constable McAuliffe have fared better under somewhat more modern doctrines? So one possibility, so let's think about the possibility of Constable McAuliffe engaging in these political activities while on the job. A significant part of his job, we can assume, was walking the beat. A significant part of what he was fired for was soliciting funds. If he had been soliciting funds while walking the beat in his police officer's uniform, is there anything in subsequent doctrine that would have protected him? If he were making a political speech while he was supposed to be directing traffic, yes, there was traffic even when vehicles were pulled by horses rather than powered by internal combustion engines. If he was engaged in a broad variety of, let us call it, on-the-job political speech, is there any reason to believe that he could not appropriately have been sanctioned? Probably not. Is there any reason to believe that things would have been different if the issue had come up in the context of hiring rather than firing? Suppose that Constable McAuliffe had a range of views about law and order, constitutionally protected views about law and order, or constitutionally protected views about civil disobedience, or constitutionally protected views about police practices. Is there any doubt that all of those could not certainly have been taken into account in his hiring process? Once again, as we know from a large number of more recent cases, there seems to be a dramatic difference between hiring and firing. And even under the Pickering regime, it may be that a large number of things that the most robust understanding of Pickering would disallow from being taken into account upon firing can certainly be taken into account about hiring. Those of us, for example, who serve on hiring committees regularly take into account a candidate's constitutionally protected views, and I do it in a state institution. I represent the Commonwealth of Virginia in making hiring decisions, and I do so on the basis of people's constitutionally protected utterances and their constitutionally protected writings. Indeed, some of my students sometimes discover that they get B- on exams. That's as low as we ever get. I don't know whether it's the same here. At least at my institution, the C has gone the way of the Tyrannosaurus and the dodo. But students get low grades on our scale. In large part because of their constitutionally protected utterances during exams. Nobody would think there's any particular problem with this. So it may be that firing is special. It would get us into interesting questions about vested rights and so on, but that may be special. But perhaps more relevantly, what if McAuliffe, while not on the job, had started to make some number of speeches urging anarchy, urging disobedience to law? I think it would be a close case. We're going to talk a little bit later today about the extent to which various governmental officials can be disciplined for their off-the-job speeches when those off-the-job speeches are thought to be relevant to their on-the-job performance. So if, in fact, McAuliffe, who was, let us remember, a police officer, had been making speeches urging civil disobedience, violation of the law, and so on, and if he was fired on the grounds that those speeches called into question his qualifications to be a law enforcement officer, that might well be these days a close case. So ultimately, if that's a close case, or if in the case of law enforcement, it may not even be a close case, it might be that all that we can say about McAuliffe versus the mayor of New Bedford is that perhaps the only way in which it's been rejected is that for some period of time, the view was, and probably still is, you can't be fired from government employment for making speeches that are unrelated to performing the job for which you have been employed. That may not be any different from what Holmes said. After all, Holmes, in that short paragraph, twice used the word reasonable. And although Holmes, without the benefit of any factual findings or analysis or anything else, assumed that this was reasonable, it's not entirely clear that McAuliffe, with its claims about reasonableness, is very different not only from what the doctrine might be now, but what the doctrine might have been at the time of Pickering. I say all of this to suggest that what we have here is a difficult problem. That's not a surprise to any of you, but it's a difficult problem of a particular variety. On the one side of this difficult problem is the fact that produced most of the 1960s cases and most of the 1960s and 70s scholarship, the rise of the welfare state broadly understood, and therefore the view that taking away someone's job, public housing, medical benefits, welfare benefits, or any of a number of other things was as effective a sanction, and maybe even a more effective sanction, than a fine, a short jail term, or some number of other things that might immediately have triggered First Amendment ire. I would be, again, as a state employee, I would be far, far more injured financially by losing my job at the University of Virginia than I would be by a $100 fine. Nevertheless, at least under one understanding of the traditional doctrine, under an extreme version of the Holmesian view, the $100 fine generates constitutional scrutiny. Firing me would not. As government largesse, as it used to be put, and there's a lot of controversy embedded in whether we want to call it an entitlement or a largesse, but let me just quote some of the 1960s literature and call it largesse. If government largesse, or if stuff we get from the government is as important to us as it seems to be, whether it be in terms of welfare or employment or health or a whole range of other things, then the notion that government stuff or government benefits is an entirely separate category, and the notion that one is not punished by the removal of that or afraid or chilled by the threat of that removal is empirically preposterous. On the other side of the argument is the view that in vast numbers of forms of government employment and government benefits or grants of different varieties, whether it be arts grants or research grants or other forms of academic grants or things of this variety. The notion that one's performance, technically on the job or technically off the job, is irrelevant seems equally preposterous. Nobody would suggest at one extreme of course, that the president cannot dismiss members of his cabinet or others for exercising their constitutional rights to lament the good old days of the Cold War when we had the weaponry to blow other countries out of the water, or things of that variety. And I mentioned the example of Constable McAuliffe's hypothetical speech urging civil disobedience, just to suggest that this is a more pervasive problem than we might think. This is not the appropriate time to suggest my solutions to this difficult problem, partly because I don't have any, but at least I want to say a few words about why I don't have any. One way of understanding this problem is to understand that it is a policy problem. That when we think about the lines that have to be drawn, when we think about the range of considerations that are at issue, when we think about the enormously complicated empirical issues that are involved in deciding which employees do which kinds of things and which kinds of speeches or other First Amendment activity would or would not be relevant to their continuing performance of their job, we are into this range of empirical, variable, complex, multifaceted, multifarious policy decisions, rather than the prototypical legal principle decision in which there are two answers and two parties, and the prototypical legal decision decides that one person wins and the other person loses. When we're in the realm of policy decisions, policymakers don't normally think this way. Policy decision makers often split the difference, which law does more than we like to admit, but still it's in some tension with the classic view of legal decisions. Policymakers often say, well, you won the last 3 times, now it's time for you to win. Legal judges don't often do that. And a whole range of other ways in which policy decisions, which I think many of these decisions are a poor fit with legal decision making. That's not to say, before you anticipate what I'm going to say, that the courts should be out of it. It is to say that the courts may not be particularly good at it using traditional judicial tools. So here it turns out that people who are not likely normally to be political allies, Justice Scalia and the legal theorist Ronald Dworkin, have remarkably similar views about this question, because both Scalia and Dworkin are of the view that courts are, in Dworkin's words, the forum of principle, and policy decisions, balancing decisions, weighing decisions, variable decisions should be left for other institutions. We all know some number of things that Justice Scalia has said about this. Ronald Dworkin has said, for example, we must strive as far as we can not to apply one theory of liability to pharmaceutical companies and a different one to motorists. Not to embrace one theory of free speech when we are worried about pornography and another when we are worried about flag burning. That's a view about courts as the forum of principle that seems in tension with the notion that maybe teachers should be treated differently from police officers, should be treated differently from cabinet officers, should be treated differently from the, I'll date myself here, the people who sell the tokens in the subways, in terms of what they can say on the job or off the job. We have a difficult policy problem that the courts have struggled for years trying to work out. First, it was Holmes with the right privilege distinction, was an attempt to deal with this problem. Then we have Van Alstyne and the courts with the demise of the right privilege distinction as an attempt to deal with this problem. Then for a long time, the courts tried to use public forum doctrine as a way of dealing with the issue. And when we talked a little bit less about employment and more about things like license plates that I know some number of you are familiar with, which is why we are here talking about this topic, but when we were talking about license plates or teacher mailboxes at a school or some number of things of that variety, the courts tried to use public forum doctrine in order to resolve these difficult policy problems. Even if you assume, in my view counterfactually, that public forum doctrine is good for anything, public forum doctrine was certainly not particularly successful in dealing with this problem. Hence, the courts started to try to deal with it through the doctrine of unconstitutional conditions. The doctrine of unconstitutional conditions took on an aura of what philosophers call ascriptive rather than descriptive. That is, it did no analytic work to say that something was an unconstitutional condition. You engaged in your analysis on whatever grounds you wanted, and if you were going to strike down the restriction, then you called it an unconstitutional condition, and if you liked it, you said it was a constitutional condition, but the actual analytic work done by the unconstitutional conditions doctrine was roughly zero. Now, it seems to me, the new government speech doctrine is serving much the same purpose. The new government speech doctrine, as used in Garcetti, as used in Johans versus livestock marketing, as used in Pleasant Grove versus Summum, and so on, once again seems to be the ascriptive label attached to an outcome rather than an analytic device that's actually helping us get anywhere. One response, and indeed it is in large part Professor Norton's response, is courts should engage in balancing in all of these areas. Balancing is a fine thing for courts to do, and I don't want to totally disagree with her here, but I do want to suggest that this may be an area particularly inappropriate for balancing. Not inappropriate for Dworkinian, Scalian, is that the proper adjective? One of the problems with having a sort of awkward name is that I can never be an adjective. I've always wanted, but I don't have a name or fame suitable for it. But the Dworkinian and Scalian view about balancing is that it's just a bad thing for courts to do across the board. I want to make a somewhat narrower point. I've spent some time looking at the lower court cases on government employment and free speech, government grants and free speech, government benefits and free speech, government stuff, including license plates, including the signs that say that this organization is responsible for maintaining this stretch of the highway, and so on. Some of you have done that as well. The most interesting thing is that there are so many of them. This is not an area that's rare. Indeed, by a rough count, the government employment, government subsidy, government grants, government stuff First Amendment cases in the lower courts outweigh in numbers all of the incitement advocacy cases, all of the obscenity, indecency, pornography cases, all of the defamation and privacy cases, all put together. That is, this area that in the typical First Amendment casebook gets about 28 pages at the end of the book actually generates more current litigation in the lower courts than all of the stuff that it's in the first 600 pages of the book. These cases come up all the time. And if they come up all the time, this may be an appropriate area to think that saying courts should balance doesn't serve the guidance function that that governmental officials might want to have in deciding what they can do and what they cannot do. So let's take the most current or most prominently current example of this problem. The controversy that arose not very far to the northwest of here, about a month ago, the Assistant Attorney General in the state of Michigan, who is, in addition to being an Assistant Attorney General, or having been an Assistant Attorney General, is also a graduate of the University of Michigan. It turns out that the president of the student body of the University of Michigan is an outspoken advocate of various different manifestations of gay rights. This particular Michigan Assistant Attorney General is an outspoken opponent of all of that and engaged in some number of public and at times not so public speeches. I emphasize the word, castigating the president of the Michigan student body. It seems to me that one of the things that the Attorney General of Michigan might have wanted to know is, can I fire this person for this range of what I believe to be, the Attorney General might have said, what I believe to be over-the-top, inflammatory, anti-gay rights speeches. Very little in the existing doctrine answers that question. We could make an argument, the one that may, in fact, be made in court. We could make an argument that there are certain commitments to equality and the like that one is expected to have as an Assistant Attorney General, but one need not otherwise have. One could make arguments the other way, that this was entirely off-the-job speech, unrelated to the particular responsibilities that this Assistant Attorney General had, that by and large had nothing to do with this agenda. But one of the things we at least ought to think about is, would it have been a good idea for there to have been some pretty clear guidance from the courts about how to handle this situation? As I understand it, this person has been fired. I assume that litigation will ensue. I haven't followed it for the last few weeks, but it is for me an example of the failure of guidance and therefore the failure, in my view, of being able to rely entirely on being able to say, well, public officials should do what they think best, and then they should rely on courts to balance the interests and make a decision. I am a fan of guidance. I am a fan of rules. That's controversial in some circles, but I will finish then by suggesting that if this is a policy area, and if we think, as I think, that it's close enough to the First Amendment, that it is appropriately a job for the courts rather than a job just to be left to legislatures or just to be left to administrative officials, even though it's a policy area. This may be an appropriate area for the courts to think about some somewhat more concrete rules. Those concrete rules are not always going to get it right. Rules are over and under inclusive. Rules make mistakes. Rules are blunt instruments. But perhaps some institutionally specific rules, precisely of the kind that Dworkin, in the quote I mentioned, rejects, would be appropriate here. Blanket rules about police officers as opposed to school teachers, as opposed to attorneys general, as opposed to other officials, and somewhat clear rules about what counts as on the job and what counts as off the job. Whether there is an appropriate distinction between whistleblowing, disclosing facts, and various other forms of speaking. At the moment, we have remarkably little guidance in this area, and not only do we have remarkably little guidance from the Supreme Court is reluctant to give us very many or decide very many cases in this area. It's not an area, unlike, for example, for those of you who are evidence people, the recent Confrontation Clause cases after Crawford, in which the Supreme Court seems to be, not particularly successfully, but at least concerned about its guidance function by deciding a lot of cases. This is an area in which there are a huge number of lower court cases in which the existing doctrine looks more like policy than principle, nothing wrong with that, in which there are very few rules that are coming out of the Supreme Court, in which there are very few cases that are coming out of the Supreme Court, leading to the conclusion that this is an area of enormous difficulty in which the Supreme Court is giving enormously little guidance. That's a problem. I'll stop with that and leave it to other speakers and other writers to think about how we might solve the problem, or whether what I've identified as a problem is a problem at all. Thank you. Yeah, you're in charge of time, okay. So you can, yeah.
Okay, well, we can take a limited number of questions because we're on being webcast and the program's being recorded. Could you wait for one of the mics so that we can get the questions recorded as well?
So I quite agree with you that this is a real problem, and I actually wrote a paper trying to come up with a solution to it. And in fact, I had no trouble writing the first 3 sections that identify the problem, but I was quite stuck with the solution.
Right.
And so what I ultimately proposed was that we should recognize a new category of speech that's neither government speech nor private speech, but recognize that there are both government and private interests in this kind of speech, call it mixed speech, and then subject it all to a very rigorous intermediate scrutiny, which sounds like the balancing that you just criticized. But my response to that is, as you say, they're sort of doing it anyway. So at least if you require them to apply this test, they'll be doing it more transparently. And furthermore, well, at this point, it may be a bit of a free-for-all. Eventually, as the courts do decide more of these cases, the rules will emerge eventually, so that each time they face a similar problem, they won't be deciding it anew. And I recognize that that hope does depend on the Supreme Court taking the cases, but barring that, that was the best that I came up with. So
I'm still, intermediate scrutiny doesn't sound to me like something that the normal frontline official understands. That is, yes, I teach in a law school, I teach about courts, but my principal interest in law is how law affects the decision makers and behavior of non-legal officials. And in the context of constitutional law, how it affects, sort of the non-legal, the non-judicial officials who have to make these kinds of decisions. It's one of the reasons why some other things that Holmes said notwithstanding, I am comfortable with rules that these kinds of officials can understand in terms of non-legal categories. Ultimately, intermediate scrutiny, whether it be the intermediate scrutiny test from the gender discrimination cases or some number of others, is a somewhat abstract, somewhat inside baseball, let us call it that, legal test. It might be more useful if that were to be crystallized in terms of the categories that non-legal officials genuinely face. That is, the difference between police officers in schools, the difference between library book selection and school employment, and so on. One of the reasons why these kinds of solutions don't play very well in law review articles is that somebody can always come up with a counterexample. We have less thinking than we should about the fact that a counterexample ought not to be fatal to a rule that works well in most cases. Indeed, most of the first year of law school trains people in just the opposite direction. We think that a student who cannot develop a position that can be defended against everything has done a bad job in the classic Socratic dialogue. Just once, I want to hear a student say, yes, professor, the rule I gave would generate a bad result in the hypothetical you just gave me, which you've been thinking about for the last 32 years. But nevertheless, it would generate a good result in a large number of other cases, and if you don't think that that's good enough, then you don't understand what a rule is. So part of what I'm interested in is rules characterized in non-legal terminology that the frontline legal actors can use in areas like this that generate so much litigation.
Thank you for that. I think your image of Constable McAuliffe is going to stay in my head for quite some time. So I wonder, I have a bunch of questions for you, but I wonder, for now, if you could talk a little bit more about the distinction you were drawing between the standards that apply to hiring decisions and firing decisions, because I was a little surprised and puzzled by that. I would have said that with respect to government acting as educator or as employer, not as sovereign regulator, but the examples you were giving, you're considering a faculty candidate, you're evaluating a student, that you still, the First Amendment does not permit you to make those decisions at either the hiring or the firing stage based on viewpoint, but it would permit you to make it on the basis of the quality, the rigor with which the candidate or the student provides the analysis, regardless of the ultimate view that they reach. So that's a content-based distinction, which is a problem if we're talking about government as sovereign, but not when we're talking about government as employer or as educator, and that the standards are actually consistent at both the entry level and the exit level.
I think one of the things that's at issue here, and it's an important question, not just about government employment and all of this, is does the notion of viewpoint discrimination get us as far as we want to get? I think that the mild suggestion in Island Trees School District versus Pico, the school library book case that did not generate a majority opinion, the court there, I think it was Justice Brennan's plurality opinion, at least suggested that there may be a difference between viewpoint discrimination and a particular kind of partisan political viewpoint discrimination, and that distinction is worth thinking about in these kinds of contexts. After all, suppose that you are a library book selector. Are you required to have to be viewpoint neutral as between the viewpoint that the Holocaust happened and the viewpoint that the Holocaust did not happen? Are you even required to be viewpoint neutral as between pro-equality or anti-equality, or viewpoint neutral as between the scientific validity of astrology? There is none. I'm sorry to insult anyone here. Or the opposing view. I think what Pico is getting at is that at times, all of these kinds of institutions, I give students bad grades for having the wrong point of view about whether Marbury versus Madison was decided before or after Lochner versus New York. I think the real issue that you're raising, and it's an important one, is under what circumstances is a certain kind of viewpoint discrimination, partisan political viewpoint discrimination, subject to constitutional scrutiny in ways that other kinds of viewpoint discrimination might not be. And like in Pico, I think the real issue, and I've written about this elsewhere, is largely about professional autonomy. Yes, we do it when we grade exams, but I think the underlying First Amendment issue there is that one of the things the First Amendment does at times is says that it is appropriate for certain professional environments to make blatantly viewpoint discriminatory judgments, whether it be in grading exams, picking books for the library, or indeed picking works of art I think that applies, as you suggest, maybe to hiring and firing, maybe upfront and back-end decisions as well. But I don't think we can fully get a handle on this unless we understand the way in which explaining a fair amount of existing First Amendment doctrine requires explaining an understanding that in some areas, the courts, perhaps entirely appropriately, are willing to say, you're the professionals, you can make the viewpoint, the content-based judgments.
Okay,